Bueno, qué bonito. Qué bonito. Bueno, buenos días. Good morning, everyone. I'm really pleased to be one more year with the Open de Arbitraje, facilitating this panel. I would like, first of all, I think it is a very, very thorough word to thank and congratulate Javier Iscar and Sonia Hernando. It is just amazing what you're doing. Every year you keep raising the bar, you keep going further, you keep innovating, you keep inventing. I don't know what you will do next year, but it will be something, extraordinary. So I really think all the community, all the people that we're dealing with arbitration, one way or another, counseling, arbitrating, the whole industry is really grateful to you too. I don't know if we could ask for a big round of applause for Javier and Sonia, please. Let me do it on behalf of our law firm as well, because we all benefit from your drive and your passion. And with that, we chose Silverstone for pretty obvious reasons. As you've seen today, A&O Shearman is the result of two big law firms that merged 2 years ago. Actually, it was exactly the 1st of May in 2024. And for us, it's a real challenge to play with the combined firm. And Legacy, Allen & Overy, which is obviously one of the merged firms, comes directly from London. It was set up in 1930, which is just 20 years before Silverstone. That's why we chose the British and the British Grand Prix, which I think is critical. As Ramon said before, the first ever sort of World Cup in Formula One was celebrated in 1950. So there's a real connection there that we are, sort of playing the legacy of where we're coming from as a big law firm, as a global law firm. And with that, I think today, the connection between Formula One and enforcement, which is the topic that brings us today, in a very aggressive way, we're going to be raising a very important topic which has to do with enforcement of arbitral awards, which is connected with strategy, with speed, with endurance, with resistance, and with the ability to really collect and cash your awards. That's why I think it was important to bring true experts in the field so that we can today discuss and try to reach conclusions on this so-called final lap award enforcement. So what is the real challenge? Many of you here are used to getting fantastic, great decisions, as it happens in football, not last night, but sometimes happens, and you get very favorable decisions and awards, but then it's the second lap, it means to collect the awarded amount. And that's not always easy. And we've seen more and more a big resistance to do the voluntary payment. And that's what brings us to deal with three key topics today. First of all, why enforcement matters. Why is it important? The second one is practical challenges and strategy for enforcement. And the third one we're going to deal with is recent developments in enforcement. Market trends. Where is the market now? Where are the courts of justice? How is it developing? I think it's a key topic that we all need to be very knowledgeable. It's fantastic to try to win, but then you need to collect. And that's why we brought these three fantastic experts today with me. First, we have Teresa Gutiérrez Chacón. Teresa is the Senior Vice President of Burford Capital. She leads the practice of Burford in Madrid. It is set up a couple of 7 months ago, and she leads the assessment and the underwriting of all risks associated with awards. Now in Madrid, representing EMEA, Burford Capital Strategy. Before that, she was Chief Legal Officer in the, I think it was in the European trading business at Pavilion Energy. And before that, you've did private practice as well for 14 years as a Senior Associate at Freshfields and Gomez Acebo y Pombo as well. So welcome, Teresa. Good morning.
Thank you.
And thank you for joining.
Thank you for inviting me.
Thank you so much. To my far left, I have Mr. Matt McGill. Matt is a very, very reputed and very well-known senior partner at King & Spalding now. Before that, he was at Gibson Dunn. And he's a very well-known lawyer precisely for all that has to do with enforcement of arbitral awards and judgments. And beyond that ability to enforce, and we will learn today a lot about market trends, about enforcement, beyond that, he's an appellate advocate. And I think an appellate advocate, he handles litigation appeals before the Supreme Court in the US, which is quite a unique and extraordinary capability, I can tell you that, because we know that very closely. And he's been arguing cases directly, more than a number of cases before the Supreme Court directly, and also participated in a number of others. He's done enforcement against Iran, India, Sudan, and Argentina, among others. And if I were to tell you in the sort of parallelism with the Grand Prix, he will be what we would call a multiple world champion in Formula One. So thank you for joining, Matt. Good morning, and thank you for being here.
Thank you. Buenos dias.
Yeah, I can tell you that he arrived from New York yesterday, so it's an extraordinary effort, and I think we should value that, and I hope we can, well, actually from Washington, right? You're heading back to New York tomorrow. So thank you very much. And then finally, we have our most important guest today, and I can tell you from my personal approach after 14 years of working together, Mr. Pablo Torres. Pablo is a senior associate at A&O Shearman. I can tell you that the work behind is unbelievable. He's a specialist in international investment treaty arbitration, international commercial arbitration. He's been involved and handled more than a dozen of investment treaty cases before exit and antitrust rules as well. And I think he's got a very well knowledge of the enforcement battles. So he's going to be able to provide us with the view of a council in Spain, but doing enforcement worldwide in different jurisdictions, why is the case. So thank you very much for coming and joining, Pablo.
Thank you, Antonio. I'm delighted to be here.
Okay, thank you very much. So with that, I think we set the scene, and I'm going to just kick off with this debate, and I hope it can be as open and diverse as possible. So I will start with Teresa, and probably let's get a bit of why enforcement matters was the first topic I wanted to address. What are the key points for a fund like Burford Capital, and maybe you can tell the audience what you're doing, how do you assess the legal risk in order to fund a litigation or acquire an award?
Okay. So first of all, just a few words on Burford Capital in case the audience doesn't know us. So we are the largest funder in the world. We are not a fund. We are a listed company. We are listed in New York and in London. We have more than $7 billion invested all over the world in litigations. And we want to double that by 2030. And one of the jurisdictions in which we relied on is Spain. So I've been focusing on Spain since October 2025 when I joined Burford, and you know, everything is going well so far. So this is what we do, and so I'm here to provide the funder's perspective. So what is it that we do when we are about to enter a case? We are assessing a fund, funding a case or monetizing an award. I will after say what are the products that we offer. But the first thing that we analyze in any case is, are we going to be able to convert this into cash? Because, of course, if we can't, then there's nothing to do, okay? It's nothing to do for us, it's nothing to do for the client. And what is it that we assess? So the enforcement risk is very relevant, and we really need to assess that. We have an asset recovery team in-house, made up not only of lawyers, but also investigators. So that means we have the internal capacity of, going around the world and seeing where companies or states have assets to enforce. And we typically look at three things. First of all, who the debtor is. If it's a commercial arbitration, then if it's a company, is it solvent, is it insolvent, does it have capacity to potentially face this condemn? That's the first thing. If it's a state, we need to know, is it willing to pay, what's the track record? Is it fighting in other cases, fighting, trying to delay this? We need to know that because this is something very relevant. The second thing we look at are the assets. So where are the assets? Which are the assets that we could potentially attach if we were to enforce a favorable award? And that, in the case of states, as you know very well, that means identifying commercial assets not protected by sovereign immunity. We at Burford have 15 years of experience, so in most of the cases, in the cases we analyze, we already have experience with these states. So we know, how are they behaving, where can we find assets. Sometimes we have located already commercial assets, right? So that's the second thing that we look at. And the third thing is, where is the jurisdiction? So that means, where is it likely that we are going to have to go to enforce? Are we going to have to go to Washington? Are we going to Australia? Where is it that we will go? Because, first of all, what is the approach of the courts there to sovereign immunity and to whatever allegations the state in question might be raising? That's the first point. And the second point is, what is this going to entail in terms of cost and duration? Because duration for us is a key risk. So we really assess the duration risk. So these are basically the topics that we will look at.
With that, you quote what?
Yeah, and then with that, yeah, we quote, and of course, it's not the same if we are looking at a commercial arbitration, and then we can say, okay, it's going to take 2 years or whatever. If we are looking at a state arbitration, investment arbitration, because of what we've seen these years, we have to assess that it's very likely that there will be a set-aside proceeding. So that is more duration. That's more time that we don't have our money. So it depends on whether we are funding the case or we are monetizing the case. But if we are monetizing the case, it's basically you have an award or you have a case pending the award, and you are claiming, let's say, 100 million euros, and I give you today, let's say, 20 million. And then if everything goes well, if you have the award, I gave you, let's say, 20 more, and then more and more, whatever, right? So what I mean is I'm going to be without my 20 million euros for whatever number of years that I have to assess. So yeah, I price, and my price depends on my due diligence. And the due diligence, these are the things that I assess, and the duration is key.
Right.
So something that we can do is like put a rising multiple. So if for whatever reason the company settles, because it's for the company to decide whether or not it wants to settle, then, you know, good for everyone.
Mm-hmm. So maybe maybe there's a reverse question, Matt, I don't know, or Pablo, that you could address, which is there a cost for the states of non-compliance?
I'd say certainly there's costs of non-compliance. I mean, the awards or judgments continue to accrue interest over time, and lots of money spent on lawyers all over the world. When I had my enforcement campaign against Argentina some years ago, Argentina spent $250 million resisting enforcement of judgments, mostly on lawyers in the United States. So there are costs for sure. What I think though is that these costs are they're not visible. And they play out over time, and that is a mismatch against the political costs of payment, which are felt immediately and are immediately present. So I think that is why you see more states resisting enforcement these days. The political costs are near term, are immediately felt, while the economic costs of non-payment play out over time and often can be kicked down to the next government.
Yeah. I completely agree. I mean, states are obviously free to not comply if they so wish, but I'd argue that it's not in the state's real interest to not comply. It just kicks the problem down the road for the next decision maker or political opponent to just pick up the tab. And Matt just mentioned, I mean, there are obvious costs to enforcement. There's legal fees. Matt mentioned Argentina, 250 million. There's another country which is very close to our hearts that has spent reportedly 90 million already opposing enforcement. There's, as Matt mentioned, there's interest. And these awards typically have compound interest, so they accrue interest quite rapidly. We have one example is an award from January of 2020. That has a principal of 80 million approximately, and that has already accrued 17 million in interest and is accruing interest at a rate of 2 million per year. But then there's the not so obvious cost of a perceived increased risk of doing business in your country if you're not compliant. You know, investors look at states that don't comply, see a greater perceived risk, and the cost of investing in that country increases. Some studies state that there's no difference in FDI flows if a state does not comply, but I think that misses the point. There may still be FDI flows, investors may still be investing, but at a completely different cost. We had a case here a couple of years ago where we had a foreign pension fund that wanted to invest in the renewable energy sector, and what they were most interested in was not just the current regulatory framework, but what had the previous regulatory framework been, what changes had occurred, what disputes arose, and whether or not the state was complying with its obligations. So I think the key is it pays to comply, and everyone's paying attention.
So a reasonable conclusion would be that short-term, short-sighted approach, political approach, ignores the real problem of what can come thereafter, right? So a more long-term and substantiated approach would enable many countries to say, okay, I need to face the award. Obviously, once you have exhausted all the avenues to challenge an award. One thing is the appeals and the annulment application, a different thing is enforcement and fulfillment, right, Matt?
It's a problem not just in Spain, but in countries all over the world, right? The lack of long-term thinking in the political class. So, and I think that it is playing out with the non-payment of arbitral awards. It's easier to not pay today than to pay today.
Yeah.
So maybe another connected in this first topic point for you, Teresa, would be if there are awards that are being monetized, that are being sort of sold, and you, Burford, or any other of your competitors acquires those, isn't there a missing opportunity for the state to settle and pay with a lower amount as a consequence, as a result, by means of finding a compromise or a halfway house solution?
Exactly, because the monetization reflects the risk, as we were saying before. The risk that we assess with all the things that I mentioned before are also the duration risk. So that means that it reflects a discount. Of course, we are not going to pay whatever the country, is willing to pay in 10 years. We are going to pay it with a discount. So yeah, that's a settlement opportunity for the state. But because of what they were mentioning, this is what we see. They are not like rational commercial players. So there are political, budgetary constraints, and this is what guides their conduct. This is what we are seeing, and this is an opportunity for us.
Yeah, so there's a missing opportunity. If we say we have an amount of 100 million and it's bought for, let's say, 50 or 60, there would have been room for a settlement of 480, so to say, because the initial investor would have been able to...
Exactly, and you would have stopped the accrual of interest, so it would have been much more interesting, right? So if you see a commercial arbitration, you would find this kind of reasoning behind the counterparty's mind. But with the states, it's different. We assess it differently.
Okay, that's an important conclusion.
Yeah.
Okay, if we move on to the strategy for enforcement, which I think is also a key point here to understand what is happening in the industry, what is happening in the market. Maybe, Matt, you could tell us first, what are the main obstacles that you face as an expert in enforcing awards, as a true expert in the US, when you're facing enforcement?
So the first major obstacle are set-aside and annulment proceedings. And then courts granting stays of enforcement pending set-aside or annulment. And what we've seen in a number of countries is that these set-aside proceedings can take 4, 5 years. I have a case against India that has been stayed for over 5 years now, while the enforcement proceedings in the Netherlands continue to play out. I mean, the set-aside proceedings continue to play out. So that's one. The other are new and creative state immunity arguments that are being advanced in countries around the world. These state immunity arguments frequently go all the way up to the Supreme Court of the various countries. In our cases against Spain, we've already been to the Supreme Court of Australia and the United Kingdom, and we're in the Supreme Court of the United States now. So these issues take years to litigate. That's a second major obstacle. And then I'd say the third major obstacle is just the finding an adequate amount of commercial assets to seize. These judgments or arbitral awards are often hundreds of millions, if not billions of dollars. It's frankly difficult to locate assets that are capable of satisfying awards of that size. So those are three quick obstacles.
Okay, any comment on those obstacles, or you see, or yeah.
I mean, certainly. I mean, it's a problem of time, as you said, and it's a problem of locating commercial assets. I mean, but thankfully there are firms that are spent their resources doing that, are especially good at doing it. But that's certainly a challenge.
It's not impossible. I mean, as we've seen with Spain, we've managed to locate the Eurocontrol account twice. So
Yeah.
we've seized that account twice, and that accrued up to 800 million euros before Spain agreed to pay the amounts into escrow.
So obviously, there's nothing new to a difficult debtor that does not want to pay. So obviously, you have the ability to delay the process and set aside and stay and all that sort of techniques, and also making it difficult to identify
Right.
assets.
All of the obstacles, tend to stretch out the timing to monetization, and that tends to be what states, their main objective is just to delay payment, make it the next government's problem, avoid dealing with the problem today. It's the short-term, long-term problem that we were discussing before.
And hence makes your investment less valuable and your IRR goes down, right? The longer,
exactly.
the more difficult.
The longer, and there are cases in which we say we cannot invest here because we don't, when we monetize, so I do three things, yes, for the purpose, for the benefit of the audience. I can fund, in this case, the enforcement proceedings, so that means I cover all the costs, all the fees and expenses of the enforcement proceeding. I can monetize, which is what I referred to before, and then I can buy an award. So if you have an award, I can buy it, and then I will enforce it, and I will control that, right? But in the first two cases, I don't control the case. It's for the claimant, so our client, to control the case. So that means that we want the client to have a high percentage in the proceeds because it's for them to control it. It's in their interest, right? So yeah, they need to keep a skin in the game, exactly. So that means that there are instances in which we might reach a point in which we say this is going to take so long that this is not going to be viable for anyone, because we would have had to obtain such a high stake in the proceeds that it's not going to make sense. Mm-hmm. So yeah.
So maybe that's a good point, how you assess the value of the asset and the risk you're facing. But maybe, Pablo, I could ask you, what kind of strategy can an investor implement just in preparation of that subsequent enforcement hurdle and difficulties that may come up? I mean, is there a way to be preventive?
Well, I think the first thing you need to do is think about enforcement from day one. I mean, it's as Teresa said, claimants don't care about winning, they care about getting paid. And Teresa mentioned, you need to look at the respondent's track record, you need to look at where their assets are located, you need to look at, depending on where those assets are located, what jurisdictions can you enforce, and which of those jurisdictions will get you the quickest and the most effective way to getting paid. But I'd argue that there's another thing that you need to have in mind, and you need to consider where you are bringing your claim, what forum. And whenever ICSID is an available option, I'd argue that it's the best bet. And it's the best bet for two reasons. It's the best bet because it has a self-contained annulment mechanism with very restricted grounds for annulment, which do not include public policy grounds. And it's also heard by an ad hoc committee, so there's no intervention whatsoever by domestic courts. And obviously that's different from mechanisms that are based on unschutzrecht model laws, where you do have public policy as a ground for annulment and which are heard by domestic courts. And the second reason why ICSID is great is because the ICSID awards are directly enforceable in the jurisdictions of contracting parties as if they were final judgments of domestic courts. And that resolves a lot of hassles. And in particular, it's also, you're also not able to oppose enforcement on public policy grounds. And just by way of example, what happened with the cases against Spain under the ECT? The ECT provides several options for arbitration. One of them is ICSID, and the other two are either SCC or ad hoc arbitration under UNCITRAL rules. And if you look at the outcome of the cases and how the claimants fared, those that chose ICSID are in considerably better position than those that haven't. We've seen various non-ICSID awards being annulled on public policy grounds, which, as I mentioned earlier, is just not an option for annulment under the ICSID Convention. And then the outcome of all of that is that ICSID awards are also more valuable when you look to monetize. They're better perceived in the market because precisely of those enforcement benefits.
So that's something you think it's important to assess upfront, just considering not only that you want to prevail in the arbitration and subsequent annulment, if the case may be, but also enforcement.
Exactly.
Yeah.
Okay, I think that's an important conclusion here. Maybe, Teresa, in this context, what would be your elevator pitch to the audience if you were to offer to an investor that is just about to face 4 or 5 years of enforcement?
Yeah.
What can be here's perfect capital, what is the offer that you would relieve the investor of?
Yeah, so I can offer 3 things. I can offer capital, which is what I explained before. This is not cheap. Okay, if you have to enforce in several jurisdictions, if you have to enforce in Spain, it might be cheap. But if you have to go to the US and you have to go to several jurisdictions at the same time, this is not going to be cheap. And it's key that you have the money to do the right strategy. So we can offer capital, but we can also offer, and for me this is more important, a strategy. So we have a lot of experience in locating assets, in locating commercial assets that can be attached from estates. We know where these assets can be. We have experience in setting the structure of where is it that we need to go. So we can add that value. Although I didn't say that, but everyone at Burford has experience at least of 10 years in a top-tier law firm. And each of us has its own expertise, so that means that we can also provide value, with regard to whatever is the subject matter that we are discussing. So that's the second thing that we offer. And we also offer risk transfer, of course, which is, of course, if I monetize the award now, and I pay you, let's say in the example before, the 20 million, I'm only going to recover the money once you are paid. So that means that for 10 years or whatever time it takes or 7 years or 5 years, whatever time it takes to really convert the award into cash, you are going to have my money. And you are not going to give the money back unless you receive the cash. So that means that as of that moment, it's for me, the risk. That's in the monetization, but in the acquisition, that's completely clear. So those are the 3 things that we can offer.
Mm-hmm. Okay, so with that in mind, I think one of the key questions I wanted to address today was, and taking the benefit of having Matt with us, is because people have heard here a lot about enforcement being carried out in the US. But why the US? What are the benefits? Why is it such a good pit lane in our parallelism here in this forum? What are the benefits for the award holder, asset recovery, et cetera, et cetera? Can you tell us a little bit?
I'd say there are 3 big advantages of enforcing in the United States. The first is the United States is the world's largest economy, and it's a massive exporter of high-end goods and services. So it's just very difficult for large countries, well-developed countries, to avoid contact with the United States. Every state is going to have some kind of contact with the United States one way or another. The second is it's a very well-developed legal system with a very well-developed set of immunity laws and precedents interpreting our sovereign immunity laws. We've had sovereign immunity laws since 1976. It's been litigated in our Supreme Court on at least 10 occasions. So there's a very well-developed legal framework within which to operate, which helps speed up litigation. That's the second advantage. And the third is the availability of what we call our discovery process. And this is particularly valuable in the post-judgment scenario. So after you enforce an award as a judgment in the courts of the United States, we are then allowed to make document requests and pose written interrogatories to the judgment debtor for information about their assets worldwide. So when we obtained our judgments against Spain, I made document requests to Spain seeking its bank account records for all of its bank accounts in 14 different countries. That's just document request number 1. There are 34 after that. Additionally, we can use what are called subpoenas and seek information from third parties. So we can seek bank account records directly from banks, from Bank of America, JP Morgan Chase, Citibank. These are some of the largest banks in the world. We can seek wire transfer information from the New York Federal Reserve Bank, from the clearinghouse. So we can get any use of the United States' Fed wire system, which is used to transfer, anytime a wire transfer is conducted in dollars, it's done on the Fed wire system. We can obtain records of that by issuing a subpoena to the New York Fed. So it's a very robust set of tools that allow you to find, to locate a debtor's cash flows and its assets. And also you can discover who it's contracting with. So if a country had a contract with, say, I'll just take, for example, Spain has a contract with the defense contractor Raytheon to buy the Patriot missile system. We can seek discovery from Raytheon about that Patriot missile system contract to learn how Spain is paying for it, things like that. And so it's a set of tools that is available, that is not available in any other country.
But what is the trigger event to use that set of tools? I mean, how do you use that exit or ancestral award into a...
So you take so once you start with your exit award, you have to file a lawsuit in the United States to enforce that award as a judgment. Then once it has been made a judgment, then you can use the discovery tools to obtain information about assets not only in the United States, but the important point is assets worldwide. So I can get, through our discovery system, I can learn about Spain's bank accounts in France or in Belgium or in Spain. So that is how, it makes it a particularly robust tool.
Okay, I think that we have 12 minutes ahead, but I mean, that is a good segue to the last sort of section, which has to do with recent developments. And obviously, some of the cases of Spain, but many other countries have given rise to a new, let's say, jurisprudence or trend in the Supreme Court in the US. So maybe, Matt, you could let us know where are things now, and how have you been able to counterattack the allegations of sovereign immunity and some others to make those awards bulletproof?
Right. So just taking our cases against Spain right now, the cases against Spain in the United States are on 2 tracks. The first is in our Supreme Court. Spain has filed a petition to have, asking our Supreme Court to hear its arguments about state immunity. And this is the intra-EU issue that everyone in the room knows about. And Spain's argument basically is that because the Court of Justice for the European Union decided that intra-EU arbitration was illegal and unlawful and made that decision in 2019, that means that Spain did not validly agree to arbitrate when it entered into the Energy Charter Treaty. That is Spain's argument. It's asking our Supreme Court to hear that case. The Supreme Court is expected to decide whether to hear the case by the end of June. Meanwhile, while that is playing out, at least 2, I'm aware of 2, and there may be others coming, but there are 2 cases in the United States that already have, judgments have been entered against Spain, and Spain's requests to have execution of the judgment stayed has been denied. So we are now engaging in this post-judgment discovery process that I spoke about, and we are on the way to starting seizing assets of Spain as they become available in the United States. So just today now, we are registering these judgments all across the United States. We're going to register them in every jurisdiction in which Spain might be playing in the World Cup. So we're going to Georgia, we're going to Houston, we're going to New York and New Jersey. So if a state plane touches down, we're going to try to seize it. So that's where things stand while this Supreme Court appeal is playing out.
Well, that was not very promising for any of us here, Matt. I didn't know you were going to go that far. Hope you cannot, you're not successful. Anyway, but obviously we're talking about law here, and we should be quite agnostic. You know, I think the key point is rule of law and fulfilling of your obligations under a treaty, which is compulsory, and that's the debate. But obviously, we really hope you're not successful with that. Anyway, any
Spain can just pay.
Yeah, I know, but you know, but we are Spaniards here. So, so maybe if we broaden that circuit, Pablo, I think it'd be great to know what's happening elsewhere, because obviously Matt has given us a month full of time, but he's given us an overview on the US.
Yep. Happy to briefly cover what's happened since the prior Open de Arbitraje in several key jurisdictions, so Australia, Singapore, and the UK. I think that the key takeaway, though, you know, there's three key takeaways. I think there's growing uniformity in how local courts apply Article 54 of the ICSID Convention in conjunction with their local state Sovereign Immunities Act. And there's a growing consensus that by accession to the ICSID Convention, in particular by operation of that provision, states have waived their sovereign immunity, such that exceptions to sovereign immunity apply and they cannot oppose enforcement in recognition of ICSID judgments in the jurisdictions of contracting parties. Second, I think there's also a growing consensus that there's no basis to oppose enforcement by operation of intra-EU objections or EU law-based arguments, which operate exclusively on a European level, but not on a plane of where we're talking about international law obligations, such as compliance with the ECT or the ICSID Convention. And then finally, and interestingly, there's a mismatch between what some courts have said on whether or not ICSID awards are assignable or not. So first, we have Australia in August of 2025, the Federal Court of Australia, that would be the equivalent of a first instance, enforced 4 ICSID awards against Spain, Reef, Nine-Ren, Nextira, and Watkins, for an approximate total principal amount of 500 million. And in doing so, it rejected Spain's intra-EU objection, the proposition that because of the primacy of EU law, that the awards were not binding, such that the exception to sovereign immunity was not triggered, and the awards were not therefore binding. And second, the Federal Court of Australia also entertained one of Spain's objections that ICSID awards were not assignable, because one of the enforcing parties was an assignee of the awards. What the Federal Court of Australia found was that there was no implicit prohibition of assignment of ICSID awards within the ICSID Convention, and in fact, the object and purpose of the ICSID Convention was such that it favored assignment of awards. A few months later, in the United Kingdom, we have a judgment from the High Court of November, which stated exactly the opposite. It read in Article 54.2 of the ICSID Convention, a party seeking to enforce meant a party to the arbitration, such that an assignee was not included, which, safe to say, I think surprised the whole sector. And let's see if that judgment stands in the future. And just to wrap up, we have judgments in Singapore, and before this, I think mentioned it earlier, before the Supreme Court of the UK, which essentially found the same thing, that there's no basis on both the Sovereign Immunities Act in Singapore, the Sovereign Immunities Act in the UK, to oppose enforcement of awards on the basis of a lack of submission to jurisdiction, a lack of consent to jurisdiction, because accession to the ICSID Convention means that one waives their sovereign immunity.
I think that connects very well with you, Teresa, because obviously these UK rulings saying that these awards are not subject to be assigned. Does that affect Burford Capital's?
Yeah, so it hasn't affected us because we have a structure in which it doesn't affect us. What I would like to say is highlight what Pablo just said, that of course awards are assignable because they are assets, they are property, of course they are. But I want to say that this decision was a surprise for everybody in the market because first of all, it goes against English prior case law and law. So this is the first decision setting out this. And secondly, there is no one international law principle setting out that awards are not assignable. So it's something completely novel, and it goes against not only what other UK courts said before, but also others in common law jurisdictions such as the US have made completely clear. So what the market feels is that this is, of course, this has been appealed, and the market feels that this is going to be overturned because we can't imagine something different. Mm-hmm. Having said that, it doesn't affect us. And what I can tell you is that if this is not revoked, there's an easy solution. You just govern the contract with US law or Spanish law.
So there will be a way around, and your industry is not in danger, right?
So what I mean is that it's a bit unfortunate for the UK to set this uncertainty. But however, the industry is, if this were not revoked, which we think is what will happen, we are safe because we have other jurisdictions. So.
Okay. Before I give you the last minute for a word, just Pablo, very quickly, one topic we have not discussed, obviously, is the consequences of the ACMEA and Comstroy rulings in intra-EU arbitration. Is it finished after that? What will happen with the protection that is provided by EU countries, which legal systems are not as reliable as maybe other?
Yeah. I mean, that's a tough one. I mean, the Commission and the ECJ have sent a clear message that intra-EU arbitration is not welcome. And its future, as a result, is rather bleak. We've seen increasing hostility by not just the ECJ and the Commission, but also the courts of member states against intra-EU arbitration. We've seen actions before the home jurisdictions of claimants, either trying to put an end to ongoing intra-EU disputes, trying to stop them from even being brought in the first place, or even trying to stop ongoing enforcement proceedings. But I'd say the future isn't that bleak for ISDS protection of EU investments. I think all you need to do is structure those investments carefully, such that you have a vehicle that is located outside the EU in order to access ISDS mechanisms should things go terribly wrong. And I think there's a real benefit, as I'm sure we'll discuss in this event, of ISDS. I mean, foreign investors are greatly reassured by the fact that their investments are protected by standards of protection that they understand and by a tribunal that they help institute.
That's an important call for our M&A partners in every law firm, so that they take us into account when they are doing their M&A transaction and they set up the structure so that they are protected in due course. We have just a minute and a half. I would like to give you the last word. I mean, Matt, Teresa, however you want. Final conclusion. How do you see this? Because this is a very, very hot topic.
The Spain saga, I think, shows that the bill always comes due. You can't avoid enforcement indefinitely. And the good news is that because Spain has so aggressively and vigorously litigated so many of these issues, the ground is now paved. It will be easier for the next award holder to enforce against the next country because these issues now have been decided up through the courts. And if you take Pablo's advice and get an ICSID award, or you have set-aside proceedings in a place like Switzerland in which they're done within a year, you will be well served.
Thank you, Matt. Teresa?
And just to add in 10 seconds that, so from everything that we discussed, my conclusion is enforcement is not the end of the story, it's the story. and there's a real capacity to turn the awards into cash, but for that we need planning, which is what we discussed before. We need a defined strategy from the beginning, and we need cash.
Okay.
We need money.
It's not the end, but maybe it's the beginning of the end. Right?
Exactly.
Okay. Pablo?
Yeah, I'll just very briefly say that enforcement seems like an uphill battle, but all it takes is time, money, and a bit of stamina. And if you don't think you have money, stamina, or time, you could, there are people willing to take the award off your hands or finance the enforcement process, and they're willing to do that because there's confidence that the system works.
Mm-hmm. Well, with that, I thank you very much, our three panelists, and all of you for your attention. Thank you very much.